Retrospective compliance, what is it? It's a principle now that has been established in the superior courts. It commenced with Bill number 2023 MCA 95 in the High Court. It worked its way up through the Court of Appeal on 2024 IECA 208, and it capped itself out in the Supreme Court with SAPIE 2024 135. So retrospective compliance is when we can act outside a section of law and at the same time stay within the act itself. Okay, so that principle now has been enshrined in the superior courts, but it's only been exercised by civil servants. Why? Because civil servants only know about it. So today I'm going to share that principle with the public. And I'm going to give some everyday examples of how retrospective compliance can benefit us and our communities and protect us against arbitrarily being prosecuted in the district court. Okay, so for example, if you park your car and you run into the shop, you forget to get a parking ticket, you come out, you get €40 fine on your car, don't worry. Go and get your euro parking ticket, whatever it costs for the half an hour you were away from your car. Wait till the matter goes to the court and go down to the district court then, and I'll give you a link for these case laws now that affirm that even though you breached that section of law concerning the parking ticket, you adhere to the broader interpretation of the act itself, having the parking ticket. So how this came about was I initiated a bill in the High Court through a High Court case. The bill number was 2023 MCA 95. I attempted to hold the Information Commissioner accountable for acting outside Section 22(2) of the Freedom of Information Act when he provided to Westmeath County Council a provision that wasn't within Section 22(2). So Westmeath County Council failed to release all my records after a month of, and their decision said no more records existed. After a month of him getting involved, they released another 300 records. So inherently, their decision was false. The Information Commissioner could not affirm their original decision because it was false. But he argued in the court that when he gets involved, it becomes flexible. The law becomes flexible, basically. And the superior courts allowed it. So when he acted outside his function, he argued that it was within the act itself. That the main priority of the act is to get the information for the public, and the superior court judges accepted that argument. Now the same argument could be made, which I'm going to actually make, which this charge that I'm facing, this threatening and abusive behaviour charge, where when I was arrested for that alleged offence, I said nothing. So I immediately complied with the holistic interpretation of the Criminal Justice Public Order Act 1994. And I will use the case law that I had a hand in creating to show that the state's case, the DPP prosecuting me for raising my voice at a judge, is bound to fail because I only did it once and I complied with the Criminal Justice Public Order Act. I raised my voice, but I wasn't threatening and abusive. That's their assertion. They felt threatened at a citizen coming into the court exercising their rights. So I'm going to put up a link into the retrospective compliance and how to apply it in your day-to-day life, because this is what most people are missing. They're the understanding on how we can use superior court cases in our day-to-day life, because a lot of the time these are far removed from what we do on a day-to-day basis, and that's what I'm going to do. I'm going to find these case laws. I'm going to start with all the ones I had a hand in making, which were these ones, and I'm going to show people how to interpret and apply them to their matters that are before the court. So under Article 40.4.1 degree, we now can rely on this. So the courts cannot choose to extend a flexibility to the public service, whilst at the same time not extending that same reasoning and principle to the greater public. Okay, so even though I didn't have any success in my case trying to hold the Information Commissioner accountable, he's actually the Ombudsman as well, the Ombudsman for Protective Disclosures. He's a multitasked civil servant, Gerdeering, and the superior courts couldn't hold him accountable, the High Court, the Court of Appeal and the Supreme Court. But through my endeavours in attempting to hold him accountable myself, I was able to draw out how he was able to manipulate the Freedom of Information Act through the judiciary. Okay, Judge Alexander Owens agreed that the Westmeath County Council's decision was incorrect, but I got my information at the end of the day, didn't I? He said, and I says I did, but that's not the point. But he said Alexander Owens endorsed the actions that lay outside a section of law, and we can use these principles ourselves in our everyday life. So get in touch if you are being accused of breaching a section of law that you can show that you complied with, or have complied with, or are going to comply with. You cannot be brought to court and prosecuted for that now once you comply with it. Retrospective compliance is now a legal principle in Irish law.